Good morning, everyone. It is a pleasure for me to welcome Mr. Prantap Kalra for our orientation sessions today. We have heard quite a few practitioners, but he's the first general counsel that we are going to listen to today. And to just briefly introduce Mr. Kalra, he's a multifaceted counsel with diverse experience, both global and local, focusing on handling business operations that span manufacturing, IT and IT-enabled services, outsourcing, sales, marketing, distribution, customer-related issues, and corporate secretarial functions. So that is, in fact, quite a wide range of things that he's handled as a general counsel. More importantly, he has also been a counsel at the Supreme Court and with law firms. So that gives him a very overall profound and holistic understanding of our legal framework and in implementing strategies to avoid and manage disputes and in instructing external counsel, which for all of us Daksha fellows here, it is going to be very helpful to know about disputes management in particular, considering we have a disputes pathway and a law and regulation pathway. He has also incessantly been involved in setting up, scaling, and handling teams and departments. Recently, at Nissan's global headquarters at Japan, he has supported the global IT and technology contracts, including connected new tech vehicles, and currently serves as the general counsel for Nissan India and South Asia. Prantap, at very short notice, agreed to address all of us, and he's also put together a presentation. So over to you, Prantap, for this conversation with our students.
Okay. Thank you, Anand. So it's a pleasure, having all you young and dynamic people with us today. But before I begin, I hope and pray that everybody is safe and continues to be safe. We all know what this pandemic has brought to us. And I think the only way I see anything happening is to just keep your hope and faith alive and just keep moving forward day after day and week after week. So with that, I think what we would do is I just put some slide decks very quickly so that there's some flow to what I say and you don't get bored from my talking too much. So we'll just dive into those. I've tried to build some kind of flow in the slides, and I hope it appeals to everybody. Okay, so here's how I thought about going some of the generic aspects, what we're going to talk about today. A little bit about myself, very briefly though, and some of the learnings that I've gained through my experience and from my mentors. A bit talk about how the tech law, policy, and regulation, in my view, is structured today, the possibilities that exist. And lastly, but not least, in the same topic, what technology and law, as a lawyer, from a lawyer's perspective, can come together with and deliver some productivity. We're going to talk a little bit about disputes in India, not too technical, but again, an overview, and probably a lot about the ODR setup that is being promulgated and talked about a lot. And last, between Anant and I thought it might also be a good opportunity to see COVID-19 and beyond from an individual perspective and also from a professional perspective, especially for young graduates who are stepping into, maybe this year, next year, in the profession. So what do I feel about it, and probably how we can together think about getting through these hurdles. Okay, so it's okay. This is a picturesque representation of, in my view, what a law student starts with, and then the various options that you can get. You can go and start your practice as an advocate in the courts. You can go into the law firms. You can do a counsel practice, and then you can. The end of that counsel practice probably is to become a GC or head a department, however you call it, and it interfaces again and again. Fortunately for me, I have had the privilege of being able to associate myself for certain durations with all these aspects of our profession. But there are a host of new options that are also coming up with the changing scenarios, which we all know is one is obviously outsourcing setup, content writing, legal content writing, legal research, wherein a lot of people are doing support for the regulators, the legislature, where they help draft policies and also garner comments with the law firms and the legal fraternity. That's also another option. So it depends on what you want to get to and what is your probably what interests you, where do you think your strengths lie, and how do you want to explore it for yourself. You could be in one or multiple at the same time. For example, if you're doing a counsel practice, all right, so you're looking at it, you're looking at any deal or project or work from the perspective of an in-house counsel, but you also have to see what would you do if it becomes a dispute, right? So you have to have that proactivity when, as an example, you are, let's say, reviewing a contract in itself, right? So while you're drafting a clause, it looks simple, but once it turns into a dispute, how will, if you are the lawyer for the other side, exploit it or be be held responsible for that clause? That could be an option. Law firms, again, you would see quickly, there are law firms who are purely dedicated to litigation or corporate as well, wherein you will get a lot of in-house kind of an experience or tax or M&A experience or litigation, as I said. So you will be able to touch. You would want to have that mindset with you. In my view, at, let's say, once you're closing nearer to your graduation, I think it's better to make up that mind so that you're not confused when you come out. Said all that, each option will require a unique skill set for you, and you will have to work towards learning and mastering those skills. And it's a long period in my view, because not from a perspective that you will never attain it. It's just that the field is so dynamic and new changes are coming in. So you have to hone your skills and continue learning yourself. Now, learning or knowing a skill does not mean you know how to use it, is my view, right? It has to be from a perspective of implementation, right? Can you implement what you have learned for the benefit of either your organization or your client or your firm if you're working it, right? It has to be visual enough, and you should be able to showcase your skill set. And only then, in my view, you are able to get ahead in any field. In our field, probably a bit more, because it's way too technical at times. So I've had the opportunity, as I said, to be associated, and it's helped me a lot. It's not easy because the expectations are different from each aspect when you're an advocate, from a law firm, from a counsel perspective. So just be mindful of that is my request to all of you. We will probably discuss how to go about some of these in the future slides. So moving forward from a learnings perspective, I probably hold a lot of learnings to myself, core to myself, but the first and foremost I hold is integrity. There is no substitute, and this has to be your foundation, sort of your bedrock. And I'm not sure if a lot of you know how, maybe people who play poker or have knowledge of it, this is table stakes, right? In my view, you cannot go ahead if you don't have integrity, and you have to understand and be able to understand what the concept of integrity would mean in each and every situation where you get into or you're asked to get into. Second, obviously, is your objective. Like I was speaking in the previous slide, you need to know your end game, right? You are probably in that situation where you have to make one of the most crucial decisions today or in the few weeks or months to come. What do you want to achieve at the end of all of this, right? So for example, for me, I had a pretty clear view, may not be completely, that initially I did not want to start with a corporate setup. I wanted to start and learn how the court procedures work. And I went with that, even though I was in discussions with a couple of law firms. And finally, when it was clear to me, I decided and I politely refused. And I went towards the court procedure side and I learned. So you need to know that. Now, in my experience all over these years, I've come across not too many law students who joined law because they wanted to. Sort of, it was their objective that being a lawyer is what they wanted to do, right? There's a cliche that you hear that, oh, we wanted, parents wanted me to become a doctor or an engineer, and way down the line it is the lawyer. So I would suggest don't be that. And even if you come to that, then be the best in that at least. Don't get strangled in the middle somewhere, because it's not going to be very prosperous for you, in my view. I may be completely wrong there. You may just turn out to be a brilliant person as well, so no worries there. But majority is what I have seen here. Now, I also know law students who initially started their education as lawyers, then went ahead and did a lot of uh, other courses and never went back to their core of being the lawyer or etc. And that's fine to the extent if if your objectives change over the period of time, which is natural, given, no problems. But you have to understand that out of all the courses that you may do, probably medicine, architecture, and law, in my view, have the longest study period of close to 5 odd years or maybe more. And there's a reason behind it. We may not go into that immediately, but there's a reason behind it, right? So it puts you at a pivot from virtually others. And I don't mean this as an offense to any other profession or work profile. It's just the technicality and the understanding that you have to attain in these professions is pretty much different, right? So don't waste your legal education is my view. You may do some other course as well, but this is your bedrock, as I said, right? So use it, be able to use it somewhere. Now, the third I would say is obviously Kaizen, which is a Japanese concept. And I learned it about half a decade or more ago, maybe more ago. It basically means continuous improvement, right? It's been implemented across industries to find ways to do things better. And I feel that it is definitely suited for the lawyers because of the professional dynamics and the changing business and regulatory requirements, which are pushing us to evolve and come up with innovative ways to managing risks, litigations, or our day-to-day analysis of any situation as well, right? Something that was absolutely okay last year is definitely not okay from a risk perspective today, right? Everybody is looking at force majeure in a very different view today. And the fortunate or unfortunate part of it is nobody knows how to handle it. You may have built all the flowery language of force majeure into your contracts, but does it hold good, or how much can you exploit it today in your contract? You do not know. And in my view, if anything is put on the touchstone of a litigation, I'm not sure it is going to reap any amazing fruits for any of the parties, because we're all in this together, right? So sometimes all the amazing draftsmanship may also not give you fruits. You will have to continuously learn from your experience. Last but not the least is, you have to know your worth, and you cannot be compromising on it. Most people, I think, they're still confused that what's their worth. And it's not to be confused with ego or pride, in my view. It's something more fundamental to you. As an example, what value do you bring? Whether to your organization or to the profession or to maybe just that one contract or one litigation that is today on your table. Are you doing what you wanted to do, and is it fulfilling for you? That's the measure that will help you go forward and keep you motivated. And my request to you would be, please do not measure your worth in terms of money. Today you may get a lot of money. Tomorrow, if you're practicing advocate, you may get to know this drill that there are high periods, dry periods, average periods. Your worth is not the money that you make. Your worth is very different. Your worth is who you are and how you are able to go forward with it and take yourself forward with it. Now, a couple of very quick pointers on this obviously are sort of relating to these 4 core learnings that I believe in. Is one is you have to respect yourself and the profession. If you cannot do either, people will not respect you. Again, please do not confuse this with ego or pride. It is simple respect that has to exist in everybody. Second, again, I recollect that I was reading somewhere that standing at one place is equivalent to moving backwards. The simple reason is because everything else is moving forward. So you have to upskill yourself. You have to invest in yourself. And in my view, there are primarily 2 big skills that you have to invest yourself in. One is drafting and one is speech, oratory skills. These are 2 that you would need. And as we discussed in the first slide itself, you may choose whatever option you may choose, but there will be a different set of drafting skills you would need. As an example, when you're drafting a petition in the court, it is different. When you're drafting an opinion from a law firm perspective, language is different. For an in-house counsel drafting a memo to the management, it's very different. Same as oratory skills. You cannot use multiple sections, what if, thereof, hitherto in your in-house counsel note to your management. But you may very well use it in your contracts or in your litigation drafting, possible. So please invest time in upscaling yourself and getting control of these skills and learn as much as possible. The next, persistence pays. Do not give up is what I can tell you in very simple 3 words. Do not give up. You will hear people say that probably some of you may be first-gen lawyers in the making as well. Or you may have a history wherein your family has lawyers. In my view, it does not matter. So do not believe only because you're a first-gen lawyer or a second or a third that it will be hard and there will be never-ending struggle. It's in my way, yes, it has some weightage, but I think it is overrated. You have to take a minute for yourself and think this. There is and there was always somebody who was a first-gen person. Otherwise, things would not have been invented. Probably the second-gen lawyers or second-gen prospective lawyers amongst you would not have been there had their first generation not been there, right? So someone has to do it. They have to believe in themselves that it is possible even if they are the first. It will be onerous on them. Are you willing to take that struggle? And I don't see any reason why you should not be. Everything is a struggle. And that's what teaches you. So don't give up, please, and do not in the same breath just run after money because that's not going to be fulfilling at the end of the day. Okay, COVID teaches us one of the very basic lessons in biology, as we learned, is change is constant. What I can tell, which I was telling in one of the earlier discussions I had somewhere else also, is adapt quickly, preferably proactively, right? You need to be able to adapt yourself quickly. If you can foresee a change, then it's even better, right? That prepares you well for something others are missing, and that puts you in a competitive advantage. Now, next, I think fifth would be move forward. Yes. As a human, you will make mistakes, right? And at some point in time, we all make mistakes. I've made so many that I can't even count. And I stopped counting after a certain point in time because, well, it does matter, but you have to learn and move forward. You cannot sit back and say, I made a mistake and stress over it and lose all your confidence about it. Doesn't matter, right? You just take the next step and move forward. Do not repeat it. Because if you repeat the same mistake again, then no offense to anybody, you're just being stupid, right? And there is a very fine line of difference between doing something stupid and something illegal. And at some point in time, it just merges in itself. So don't do those mistakes and don't repeat. Now, last but not the least, I think it's a bit more negative. I'm a very positive person with positive outlooks, but I think shortcuts, in my view, are not the best way. There is a difference between smart work, hard work, and a shortcut. Shortcut will get you cut short in the long run, is what I believe in. And I say a lot of time that people who take shortcuts get cut short in the long scheme of things, because you will not be able to sustain yourself. So please be mindful of these. And if you can imbibe these in your day-to-day routine, in your profession, and I'm sure you will have a lot of success in the years to come. Coming to my view on technology law, policy, and regulation, as I see today, while you see what you see on the screen, these are 5 big points. But what I want to tell you is, in my experience, I have not seen many legal professionals who really understand how technology today works, right? You have to go back in time in probably, in one of the best presentations that I have seen is of the iPhone 1 launch of 2007 by Steve Jobs. Everybody would say a lot of things about that. Yes, there must be all true. My view is what it changed fundamentally for everybody is it gave you the power to visualize. It changed all the text that you used to have on your phone and put it in images on your phone. That frees up your mind. It makes it endless, because now you're not reading the text on your phone. You are correlating the image or the app icon and you do your things. So you're visualizing more, you're imagining more. And as I see in hindsight, from 2007 till today, a lot has changed in technology, and it will continue to change. There is no holding back on technology, right? So we have to prepare ourselves. And I've been in situations where I've been discussing contracts on technology, and I ask these questions that what is the architecture of this tech? And the counterpart does not know it. You have to know the architecture of the technology, because the architecture of the technology gives you a lot of information. For example, what are the data access points, right? Let's say if we take a very rudimentary example of WhatsApp, okay? You use WhatsApp, you download WhatsApp, probably 98% people don't read the terms and conditions, which is absolutely fine. But if you're a lawyer, you need to know what are the data touch points. Who all in the external world are touching your data, right? Or which softwares touch the data. That's where your vulnerability exists, in that software, right? Now, vulnerability can be in other places as well. So how do you test the vulnerability of the whole system? That only comes when you know the architecture. And when you interface with the tech team to understand how they have built it. You don't need to reinvent the wheel. You have to be able to ask the right questions. And most do not. And that's, I think, the big gap in our system as well. Probably some other countries have evolved to that extent, but we lack expertise and conceptual understanding of a lot of technology that is being used today. And that's why we are behind and attempting a catch up. Now we talk about data protection, everything we talk about today. While we started on the policy framework, we're still to see how it works out. But we also need to talk about information security. How do you maintain your data secure? Whether it's a tool provided by the government or a third party or even an organization. That also matters equally, because if you'll go and do a very quick research, you would see how many phishing, malware, etc. attempts get made on various organizations, various governments, all through the day. And this is in thousands and thousands, right? So how do you protect that data? You have to have your firewalls, etc. ready, right? Now, what obviously COVID also teaches us is that every now and then, we come up with a knee-jerk reaction to something that we face, right? It's sort of, we're firefighting. We do not have the checks and protocols that assess the risk firsthand, but we place mitigations within the framework, and it's sort of a band-aid approach, if I can say that, right? It's not a cohesive approach. We don't have that. We're lacking it. Now, what we need to do is we need to have mitigation factors which are placed within the system or the framework, which should be robust enough in the first place. But once they're placed, they can prevent or contain a fire up at least till the time the firefighters arrive, right? That's generally your aim. When you're doing a construction in a building, you put the equipment so that it delays the fire or stops the fire. We have none from a technology perspective, in my view, today. We are just, okay, there is an issue that happens, okay, let's do something about that first. Okay, and another will happen and another will happen. It is a never-ending scenario. While there have been attempts, how cohesive they are is doubtful, in my view. So it's like putting the cart before the horse is how I see our framework today is. Putting the cart before the horse and then complaining that the cart does not move. Which in my view is a very strange approach. And we need to step up and do something about it and be faster in it. And probably in the next few slides, you would see where I see the problem lies. Now, taking, for example, again, COVID, right? It took a pandemic for us to realize that we do not need to think out of the box. You would have heard this in a lot of webinars, motivation speeches, that think out of the box. But in my view, what this pandemic teaches you is that there is no box. Where is the box? We are forced to reinvent our thinking. We're living in a very different scenario, like a caveman probably, with tech available. The tech usage has changed. The legal aspects are being forced to change, which were till the time probably COVID happened, which were so strict that nobody wanted them to be changed. The justice delivery system has changed. And potentially the list is endless. And it will continue to remain endless. And I hope this traction is not lost and we build the future on it. And we learn and we don't take this as a completely negative approach. Moving forward, from a possibilities perspective, very quickly that comes to me is, obviously, goes without saying, data protection. There is no two ways about it. It's the core today. Like you would have heard again, is that data is the new oil, and this was the term that probably goes back about a decade, give or take, right? But we are realizing it today, so we are way behind the curve. Now, possibilities obviously are endless, and because of the scenario we are in, we're just scratching the surface of technology iceberg, in my view. Now, you may call it whatever you may, So Technobar, if it catches the fancy of some of you, yes, you are actually witnessing this today, in my view. And a couple of years, probably a decade or half a decade ago, I said that no matter what we want to believe in, our beliefs will not be questioned. Rather, they will be shattered with technology being the driving force. And that has been happening over the last decade. If you just try and see how technology has changed. Now, we can either accept it and adapt or be left behind. The people involved with this innovative technology have only given us two choices, in my view. Either we go digital or be digital or be left behind. It's for us to choose. Now, looking at the examples of mobile applications and e-commerce, we knew about this. E-commerce, everybody knew about it because Flipkart came in, Amazon, etc., etc. There was a sudden boost of mobile apps, and now you see the digital content going forward. Initially, it was just, I believe it was just Netflix. Now you know how big it is. The other possibility, obviously, is that's being talked about now is medical records. How do you protect the medical record of a person, COVID tracking, Arogya Setu app, etc., etc. There's also another scenario of drones, the drone policy. How did it work out? We're yet to see a really great framework there as well. Again, in my view, sketchy. Connected cars. A lot of people talk about connected cars being implemented in India and across the world. I know it is existing across the world. Globally, it does exist. In India, do we have the infrastructure? Do we have the regulatory framework to do it? I don't think so. So these are some of the possibilities wherein we have to speed up and get to the end game from a regulator perspective as well and the policy framework perspective as well. Now, to give you a flavor of how things are changing from the regulators when it comes to, let's say, the automotive industry, is regulation will keep coming. How do you take those forward is in the next slide very quickly. Is I've tried to span out some of the changes that the regulators have implemented, plan to implement this year or next year going forward. So as you see, very quickly in 2019 there was a help button in the cab aggregators, ABS, crash norms were notified even in India, the airbag usage came in, the 80-20 rule for speed came in, etc. This year, obviously, we've graduated, we've jumped from 4 to 6 on BS norms. Next year also, there are a lot of things planned. So as a lawyer, you will have to come up and you will have to change because the regulations will keep changing. Some of these will be easy for you to do. But when the technology starts coming in, it becomes difficult. For example, if I put in this slide a connected car solution for you, that changes the whole dynamics of everything. Nobody is prepared for it. How do you work that technology framework? Where do you host the data? Whether you will locally host it? Where are the vulnerabilities? How do you protect customer data? What could be the liabilities? That's a Pandora's box waiting to open, but at some point in time, we will have to open it. Do we have the expertise and the intent to manage what comes out of it? Will matter. That's the intent part. Now, coming forward from all of this, while all of this will change, what I have seen from a technology and law perspective for lawyers, now we are sort of moving away from the tech law policy and regulation to pure technology usage for doing work that the lawyers do. More and more, the ask that is going to come is for the legal departments, whether even if it is the lawyers who are practicing in courts, is to be more effective, efficient, and evolve. These 3 E's have to happen in your system, right? I have seen a lot of lawyers, they don't even use the basic tools, right? And the worst part that sometimes I feel sad about is they don't even know that the tools exist. I've been in those situations where I went and asked for, let's say, a PDF creator, which helps you combine multiple documents because lawyers do a lot of scanning, etc. You can merge and then send the document out. You don't need to scan everything again and again. And there were a lot of people who did not even know about this. And I was asking of these kind of softwares almost a decade back, which is a funny story, right? Because you're supposed to know what is happening in your field, which can help you become more productive. So optimization and legal departments, these two concepts have to go together. You have to dedicate yourselves towards technology implementation. And we, as the new lawyers, young lawyers, have to lead by example, right? It can have a very good impact on you, on your organization, and also on the legal fraternity at large when you use technology for effectively delivering your service. And you might be doing whatever you are doing, whether as an independent counsel practice, law firm, or in-house, right? You have to take a moment and think again, because this is the opportunity where you will be able to bust a lot of rhetoric in the system and in the mindset of people. And this has the potential of creating new pathways for legal service delivery, in my view. Now, if I have to quickly touch upon some of the utilized opportunities, we all know is we have a lot of case research tools. We do accounting from a law firm invoicing perspective, work management, e-discovery, everybody knows that just ramped up itself from an outsourcing perspective, and document storage. The core things that are not being implemented, and I believe the challenges that we face are because of conservation. We are pretty conservative. We still believe and hold the traditional ideas very dear to our heart, and we have weaker cost checks. For example, and again, this is not a comment on anybody, the law firm bills you everything on actual if you're an in-house counsel, so it's absolutely fine. I think probably no, because now what we are seeing is all organizations, irrespective of sector and industry, are having to do an effectiveness and efficiency check. So you're being asked to keep your costs aligned with the overall objective. How do you do that? You do better cost checks. The reason is the future is pretty clear. The organizations, the end customer, everybody wants simplicity of use, swiftness, and enablement. And that is true from lawyers also. You will have to deliver these three things to your business or your client. And that will, in my view, put together the final mantra for your success. Now, in my view, again, unexplored opportunities are contracts management. Definitely, at least in the Indian framework, not a lot of organizations use it. Workflow management for the whole department. Are you effective enough? What is your utilization? Are you overburdened? Nobody does that mostly. Very quickly, again, matter case management. I've seen organizations and lawyers not being aware of where the case papers are, where the files are, what is the stage. That's a big no-no for you as a lawyer. You need to know if it is your matter, it is your matter. You need to be able to provide the information quickly. Knowledge continuity transition is another aspect. Document repository, you have to go digital, right? Everything cannot be paperwork. You cannot lift files and move around every time. So it has to be available in a secured environment. Invoicing and payments, yes, for law firms, it should be quick and it should be digital in my view. Process automation, yes, this is extremely important because it helps relieve you of the work pressure. If you have a process that is good enough to go from point A to B to C to D without having too much interaction or involvement from your side, then you can be involved in your strategic matters. Digital signatures, yes, definitely. We never used it to a good extent, but it's high time we start doing it now as well. Now, overall, when we talk about tech law, policy, regulation, lawyers, I just wanted you to take maybe 5 seconds and look at the next picture, and I'll come to what it is. Right? This is a cartoon, and and I think it was published in around 1930s. Okay, and when I give you the context in the next click, you'll be able to see what's probably happening, and that's my request to all of you as well. Is this? This is a cartoon that was published in 1936, depicting how probably the finals of an Olympic in the year 2000 may happen, right? So about close to 64 years back, somebody was envisioning television technology, radios, applying wireless technology, which probably was just a thought, but somebody visualized it in thought and went ahead and said, I think that this is going to happen. And it did. Now, you have to see how people in technology, etc., work, right? They think beyond decades, probably centuries, I don't know, half a century. This definitely showcases you that. We have to think exactly the same way. Otherwise, we will be left behind. Our regulations have to be visionary in nature and should have the capability, in my view, at least to preempt, if not half a century, then at least 2 decades. We cannot sit here and say, I made a law which is going to be good enough for 5 years and then something new happens. No. We have to interface with the experts who are working in the technology field to understand what are they going to come up with, what's their thought process. If we cannot do that today, we would have failed the future generations, is my view. So when you go out, please have that vantage point of years to come, not just few months or 1 or 2 years. And probably that's my request at large as well. Now, as I said a couple of slides back, where do I see the problem? We are very good at identifying problems. Let's say data protection or drones policy, etc. So we know that we need a solution for it. So we got an idea. And this is a very simple framework, in my view, about how the whole process works. You have a problem, you get to the idea, you strategize, you formalize the policy, you implement it, you evaluate or reevaluate, and that's it. I think in our context that we talk about tech law and policy, from the time the idea is born till the time it is formalized, the gestation period is so long that a new technology comes in and overrides it. And we are still developing something which is probably old or may have become redundant. And even if we are able to meet this whole timeline, our implementation is always questionable and we never go back and reevaluate. We still live with old laws, which probably are good enough, but they're not the best in today's scenario. And in my view, this is where we are lacking. Implementation and evaluation or re-evaluation does not happen the way it should. And ideation to formalization is, again, too long for anything to take or bear fruits. So that has to change. And you have to, if some of you go through with this option of being or a participant in the framework, policy framework, etc., then my request to you would be, please think about how you can quickly deliver and change and bring the change which is long lasting. And even for others also, if you're doing a deal, please think about long term in the future and how the change can affect in a better way. Now, going to the sort of the second last part of my talk is the disputes. Now, if you see, traditionally, we've always had courts, then tribunals were created, which are special courts, and then came the ADR system, right, which was thought to be really great. And then ADR obviously is set of arbitration gets the subset into arbitration, mediation, conciliation, lok adalats. And of late, we are seeing a lot of ODR. That's nothing, probably online dispute resolution. Some people call it EADR. You may call it whatever you feel like. I think the basic connotation is the same. The challenge is most of the ADR has been successful only in parts. There is no extensive utilization, or if I say conversely, it has not substantially reduced the burden of the traditional court system or the tribunals, which it was expected to, right? I may not fully agree that the future lies in ODR for India. That's a statement that was made for arbitration as well, mediation as well. It's never done. It never happened. And there are multiple reasons for it. For example, if you take mediation, mediation has always had enforceability issues, right? Consequently, there is low demand. Another reason therein is the mediator's capacity and infrastructure availability. There is also a missing centralized authority or an authorization for a mediation process, right? So how many, and I asked this question to myself again without offense to anybody, how many will want to involve their disputes along with a toothless tiger? Not many, right? But then, again, as I said, it's not an offense to anybody, but you have to be able to call a spade, right? And that has to happen. Now, the reason, going back to arbitration, is the reason initially arbitration picked up was the potential of reducing the existing long lead time in commercial disputes, certainty of enforceability, and cost controls. Now, along the way, as we all know, these beliefs were eroded. And frankly, we are all responsible for this. Right? This erosion we have contributed to this. Whether we like it or not, this has also left a scar on a lot of people. And things cannot be repaired completely unless everybody comes forward and says, okay, we are all committed to doing this the right way, right? This, you would see this issue resonates with the mediation reasons I just now told you, the low adoption of mediation as well. So what we need to ask ourselves is, while we may have had a good idea or ideas, probably we are failing in execution. And frankly, the proof of pudding lies in eating, not in looking. I know this is a digital age, so you know what looks on Instagram, you can click a photo and people think it's amazing. And the food must be tasty. But only after you eat, you get to know whether the food is actually worth it, right? So I think we've been failing there, and probably miserably at times. Now, again, ODR definitely holds potential to scale up. Arbitration. But unless we address the elephant in the room, ODR is bound to fail as well. We're not providing the right set of framework even for ADRs. We are going through that process now after decades. That we should institutionalize it, we should have some set frameworks, timelines, etc., etc. A certain kind of category of dispute should definitely go for arbitrations. This has to be thought at the first place. It's not supposed to be thought after decades. You're supposed to be able to preempt these things. If you're not able to preempt or think about these things, then your thought process is flawed in my view. You're shooting in the dark without the knowledge of what you're shooting at, and also without the knowledge of what you are shooting with. That's a collateral damage. And then all you are doing at the end of the day is picking up pieces together of the damage you've done. And that's, in my view, that's what we are doing, right? We have not been able to scale up arbitration, mediation, and ODR as well. ODR is very good. As we have seen, the justice delivery system is now changing, right? Because we have e-courts, courts are hearing petitions online, but how many? Are all the cases going to get heard this way? Most probably no, right? Only urgent hearings. Now, take a very simple question. ODR, let's say the e-courts possibility in the district level. Are we prepared for it? Do we have the infrastructure for it? The answer, we all know. Right now, no. When will we get it? We do not know. Are we working towards getting it? We don't know. Right? So now you put that on one side and then bring ODR. So how will you utilize ODR in a dispute resolution? So ODR is also again going to be utilized by people or organizations or parties who can afford this kind of technology, right? Who can go and sit on laptops and Zoom calls and do the dispute resolution or argue their cases. But there are some practical challenges to that as well. For example, evidence, cross-examination. You would definitely somewhere lawyers coming back and saying that, you know, cross-examination should still happen in person. And sort of I would align with that view, yes, because there's a lot of nuts and bolts when you're doing a cross-examination in person, because how a person reacts to your questions also formulates your next question, and sometimes getting truth comes easily that way. So there are a lot of challenges here. Potential is not questioned, implementation is, and as I at the cost of repetition, that's been the problem all through for us, as we saw in the slides, from ideation to formalization to implementation. That's where we are not hitting the right targets. Now, very quickly, in the interest of time, I think we're close to 50 odd minutes up. I'll go to the next slide for COVID and beyond, because I think that's really important. Is while you are at this stage where you're going to be the next generation, if I may say so, for lawyers. So please have a clear mindset, have your goals clear, have your priorities clear for yourself. That's very important. Know your strengths and write them down. When I say write them down, it could be your resume or your CV, or just for an example, have an introspection. What am I good at? Am I good at drafting? Okay, so probably I want to do a corporate kind of a role or an option. I could be a content writer, I could go to law firms, I could do contracts. Now, when I say write it down, may I also say this? I have seen so many resumes, one-pagers, wherein there are spelling mistakes, grammatical mistakes, and sometimes people not writing the truth as well. Please don't do that. The reason is, the reason is very simple, or reasons are very simple. If you cannot articulate your profile in one page without making mistakes, then how do you put confidence in the organization or the interviewer that you will be able to draft a 30-page contract or a 300-page contract without mistakes and putting liabilities, right? So please be mindful of that. The other part, as I said, write what you know and what you have done. I have been on so many discussions where people write, I've done contract management, and when I start asking them questions, okay, so what are the top 10 risks, etc., in a contract? Then they come back and say, for me, contract management is scanning the contract and filing it and documenting it. Okay, so that what it shows to me is you don't know the subject. You have to know what is contract management, or be able to specify there. If you're doing those mistakes, they will show up at some point in time, and you may not be able to fool everybody there. So please be very specific and very clear of what you do. Learn learn and learn. Please be open to learning. You are at the very first stage. You have time. You can invest, and you should invest in yourself. So please do that. Learn and invest time, and security will automatically come for you. It may take a little longer than probably you are expecting, but it'll definitely happen for you. Now, to bust some of the thought process that people have, perception versus reality. Nothing goes up, right? The path, whatever profession you choose, the path you take will have a lot of twists and turns, right? That's fact of life. Success does not happen overnight. Now, yes, it happened one night for which a person may have had to prepare for many years, sometimes decades. It depends, right? And things will never go as planned. They're not supposed to go. It's a process. You have to live through the process, which amplifies your experience and your maturity towards the profession or you as a person. So if you're having a belief, as you see on the left side of the slide, which is the perception, then my request to you is please rethink. The reality is very, very different. And this is not to scare you. This is to help you understand that you have the strength to go through the reality. But you will only have that strength when you consciously understand what reality looks like. So do not fool yourself about it, but be prepared for it and prepare yourself and go through it. Now, the last slide, this I prepared very, very quickly, but I hope you can see here, and I'm going to use the pointer here. And this is what I use for myself, so I thought probably it might help. So this is your life in my view, and my life in my view as well. Anybody, I've spanned about 80 years of a human life here. I've attempted to, and I hope you live beyond 80, 100, 150, whatever you wish. So from the top, we start at 0 on the top left, and we go far right to 80. So this is 80 years. From top left to bottom, you would see 52. That's 52 weeks in a year. So that's each year is divided into a week, and that's your whole life, in my view. The first 18 years, everybody is visionary. You will never see a kid who does not have a vision, whether you want to be a superhero, whether you want to be an astronaut, or you want to change the world. And everybody gets sent mostly to school or schooling. You would spend almost 18 years, which is close to 22.5% of your life schooling. And then you would go to your college and you would get your degrees. That's another close to 8% added. You are in this blue area today, wherever you might be. What I want you to acknowledge for yourself is that 30% of your life is done. You have a 70% left, give or take. And out of that, by the time you reach 40, 50% of your life will be over. And by the time you reach 60, another 75 is over. And all through, after you've finished your education, your higher education, you will be on your own. You're supposed to be. So make the right choices and do the right things, because this is the playing field. From 25 till 60 is the prime playing field for all of us. After 60, yes, you may want to continue to practice or whatever it is. For leisure or for acumen purposes, that's absolutely fine. But your prime years are here. And if you see very clearly, you're spending most of your life in the middle. And 30% is give or take over. So what's your life going to be after this depends on what you do today. So please be very mindful of how you want to go about things in life. I am going to stop here, and I'm going to thank all of you for bearing with me and hearing me talk. And I hope it was beneficial. Uh, Anand, I'm not sure how you want to take it forward. Probably more
Yeah,
questions
absolutely.
or
So,
okay.
first of all, thank you, Mr. Kalra, because I think about everything else that you said about how to, plan your career and all of that, I really, appreciate the fact that you highlighted the value of integrity in the profession. The one thing I would like to just say at this point is that while we have designed an extremely flexible program at Daksha, the one rule, and that is very, very clear in our fellow handbook everywhere, where we have a zero tolerance approach towards is plagiarism. Because we believe that you may make mistakes, whatever you do, let it be your own mistakes. You may not be original, but let it be your own unoriginality, right? So we have insisted on that one thing, and even while selecting our fellows, we really looked into, for instance, the legal essays that they submitted, whether it's original work or not. And I think everything that you build on should be really on that foundation of originality and a fair level of integrity that comes into your career. I'm sure that students have some questions. I have a few of my own, but I will reserve that to the end if we have some time. So I'll welcome each of you to raise your hand or just go ahead, unmute yourself, and raise your questions to Mr. Kalra. I'm sure you have a little bit of time, sir, to address this. So over to you, fellows.
Good
Yeah,
afternoon. Hello.
Sure.
absolutely. No, go ahead. Please go ahead.
So it's it's amazing to hear to you, sir, and like everything you said, right from integrity to everything, whatever has to come up next after the once the pandemic subsides. I just wanted to ask and listen to your views. What do you think after the pandemic the opportunities would be, and how should we be mentally prepared to deal with them? If you could give an insight into it. Thank you, sir.
Okay. Uh, Thank you. That was Abhishek, I believe. So, Abhishek, thank you so much. I think that's a very, very valid question. When I say opportunities, right? So let me just be very blunt. We don't know. Okay, but what I trust is what I trust in is this country. You have to trust in this country. This country, our country, has the potential, and it will showcase its potential, is my very firm belief for everybody. Okay, for us, the opportunities would be, in my view, today there is a lull, right? All organizations, governments are pulling themselves back, and they're trying to see what's the playing field, right? Because the playing field sort of got leveled because of COVID. Now, once they have a complete or maybe a good enough view of the playing field that exists, you will start seeing opportunity come. For example, okay, as we were talking, force majeure issues, they're definitely going to happen. You like it or not, right? You may have not been able to produce, so your supplier is having a problem with the finances, right? Or the supplier has a workforce problem. These issues will come, and organizations and the government will have to address these issues in some way or the other. And these may be policy, regulations, whatever they might be. But when they will be debated or deliberated, the final outcome will come from some court, in my view. That's where is an opportunity where I see probably some disputes or nature of disputes rising. Okay, so that's when I say the court practice part. In-house counsel. Let me come to that also. In-house counsel practice or counsels in the in-house roles will definitely be required. Their views and their positions, while already pretty strong, will get strengthened because now you are being seen as a business enabler all the more because you are now having to protect the entity and to showcase the next way forward from a contracts perspective or dispute perspective, right? Because of all this. So if disputes increase, then will the existing headcount probably, because mostly all in-house teams are generally leaner, is that enough? Probably not if the disputes start going, number of disputes increase. Coming to the law firms, again the same scenario, if I can say, if the disputes in the courts or within corporates will increase, the involvement of law firms will increase, right? Now comes the other aspect of policy making and regulations, which we are already seeing that is going to happen. As you would have noticed, there is also a talk that labor laws should go under reform, right? And if you see the history, every time there has been a situation like this, right? You can pick the world wars, you can pick the pandemics, whatever. There has always been a change in the legal framework, which has had ripple effect across decades, right? You can take the taxing system, which I think got introduced around the world wars or the aftermath of the world war. You know about the emergency, I'm sure you know today. So opportunities will come. The other opportunity obviously is content writing. I very squarely, fairly believe in it. There is a voice that is with the people, and all the more with people, young people like you, all of you, because you are the new thought process. I am not, right? I am to the extent I can be. You are the fresh blood, all of you. You bring innovation, ingenuity out. You can think forward, and you have to bring your points out. You have to write about it, in my view, without obviously defaming or all the other stuff that keeps happening. Okay, because you never know when your idea is the game changer. But if people don't see those ideas, people never know about those ideas. So those are the options, and I would encourage all of you to write, because that also helps you harness your skill and increase. I was not a draftsman from day one. Right? I was so bad that if I look back today, I would probably not keep myself, in my own office probably. But that's how you go through, right? You're not there, but you have to aim to be somebody. So those are some of the things that come to me very quickly, and please engage in the profession in the most productive manner. Does that help, Abhishek?
Yeah, thank you, sir. Thank you
Okay,
so much.
thank you. God bless.
More questions?
So may I?
Please.
So thank you so much for taking out time and giving us such an illuminating presentation. I totally loved it, sir. So I want to ask you, like you said, you started off your career as a litigating lawyer initially, that you wanted to learn the procedures of the court, and thereafter you proceeded to be a general counsel at Nissan. Nissan is again a Japanese big corporation, and Japanese are genuinely known for being the torchbearers of advancement in technology. Uh, from there itself, the philosophy of Kaizen also evolves. It's again a Japanese philosophy. So this is one thing that I picked from your presentation, sir. Now, my question is how this Kaizen, the self-improvement, has played role in your life as a general counsel, as in how your role has evolved since the day you joined as a general counsel at Nissan.
Okay, so let me do this. Very good question, Abhishek. So let me go back to the trajectory slide, and probably we can quickly address all that. Okay, so here's the big thing. Okay, so I did start because I wanted to know that what happens in a court from my perspective. That was a personal pursuit. How do two lawyers arguing a matter view the same thing in a different manner? And then how does the court decide on this? And why does one person's view will prevail whereas the others may not? And what's the logic and the legal reasoning behind it, right? And it used to be very fascinating for me. It still is. Now, when you get into the in-house counsel setup, it changes a lot, right? As I say, first thing you lose is your freedom. When you're an advocate, you don't want to take a case. You can say no, right? But when you're the in-house counsel, your integrity and your commitment is to the organization, which is the company, right? As we read and learn. And one of the first things that I've seen is lawyers are completely risk averse. If you give them an option, everything will be high risk and nothing should be done. And this is with utmost respect because I am a lawyer. Okay. But what people you have to take it with a pinch of salt, because in my view, you are doing the job of the undertaker, right? At some point in time, for whatever reason or unknown, relationship may fail and dispute may start. That's what you think of, correct? That if a dispute happens, how do I protect my company? So what you do is, there's a very good joke about this. They say that a lawyer is a person who writes a 10,000 page brief, 10,000 page document and calls it a brief, right? So we have the habit and we have the expertise to articulating it. Yeah, you articulate the risk. Now, how much is it actually practically a risk is the question that changes from a counsel practice to a GC practice, in my view. You have to be a strategic partner to your management, to your business heads. There may be 20 risks, okay, or 10. With your foreseeability of a 3-year contract, how many can come true? Leave aside COVID for a minute, right? Leave aside COVID. In a normal business scenario, what would you want to take care of? Now, without taking very quick examples, let's take any service contract. The first thing that you may want to see is, do you have an exit right or not? Does your exit right come with a cost or not? Correct? That's your first thing, in my view. You may pick any contract, any millions of contracts, no problem. What is your exit right? Do you have to pay to get out of it? Right? If you have that, then I think you are covered in one of the most basic ways to move out. If your business suddenly decides, I don't want to work with somebody, okay, you have the right to move out without paying. So if my counsel comes and says, oh, I have this indemnity, I have a LOL cap, etc., etc., can I move out? It does not matter. All of the things don't matter. If I can't move out and I'm stuck to that, right? Then you have to live with it. If there is a lock-in period, you're stuck. So your advice changes. Your vantage point changes. You have to think like a business person, because your job is to enable the business. Because if you keep having a risk-averse approach, no business will get done, right? If I tell you this, okay, very simple example: stop sleeping, because you don't know whether you will wake up or not tomorrow. Will you do that? Stop sleeping and don't ever sleep again. That can't be the approach in life and in business. You have to understand that sleep is important, equally waking up is important, but how much sleep is important is the question. So when should I set the alarm for? That I am fully productive. So your alarm is sort of your exit, right? So you are in a hibernation mode for 8 hours and you exit out of it, no problem. But if you wake up with a headache, that means there is an indemnity issue or a liability issue you are facing. So if I can sleep, if there is something that does not allow me to sleep in the night, then it is a problem in the document. If I can sleep, then it is still okay. And you have to go and talk to your business. A lot of time what happens is counsels don't talk to their business. They just say, here are your 10 risks, done. you have to talk to the business to understand whether they understand, right? So I think the basic is that you move from a counsel. So you would see, if I can put it again very quickly, if I say here, if I term this section as a lawyer, right? The advocate practice in the court and the law firm as the lawyer. Lawyer becomes a counsel. Counsel is not a lawyer in my view. Counsel is the person who counsels, gives advice, right? That's the change that you have to be mindful of. You're no lawyer, you are the lawyer for the company, so you're the counsel for the company. You have to advise the company. You're not supposed to go head and head and start fighting with your business. No, you are wrong. No, that's not the idea. Okay, and then when you move to the last leg, you have to change your perspective even further. Now you have to be sort of the light at the end of the tunnel and start finding solutions and be able to articulate the risk to your business head and say, okay, here's my thing. I'll put my name on this. Generally, it is very risk averse approach, right? No, I don't want my name. I did not approve it. Business approves it. But you will have to put your name to that tag and say, I was part of this decision-making process. So you have to have that inside you to be able to move to the next step where you say, good or bad, if this situation goes south, I'll still be standing here to defend because I was part of the decision-making process. We all were. So there is this oneness that has to come in you along with the business. Does that help?
Absolutely, sir. That answers my question. Thank you so much.
Thank you.
On the point of ADR, you've taken a very contrarian view, that it's not helped sort of unburden the judiciary, so to speak. Do you have any studies to back that, or I mean, is there any sort of literature to back that statement? And my second question is how important it is to be contrarian in the legal arena.
Okay. Okay, so I was trying to get to the slide. Okay, which is very good question, Sharad. So now when you say, okay, my view is contrary, yes. I don't say that it has not benefited. I say that it is, when I say, I think I said it is successful only in part. And yes, I agree with you that it has not reduced the burden. The reason is, if you analyze, in my view, your primary disputes that happen in the court are probably family, family related, property related, and one or two more, right? Now, if you see these disputes, how many of them can actually go to ADR, right? Can a family person take a dispute to the ADR arbitration? Not possible. Real estate, mostly not possible, and even the courts are aligned because the evidentiary value comes into picture for these. And family is again, so family has the mediation concept, which is very good, but mediation is again optional, right? So that becomes the issue. There are studies, probably I can send some of the numbers to Anant as well. The idea is, now let's go to arbitration as a third measure. Right? Arbitration was supposed to almost kill the commercial disputes from the courts. Right? That was the original thing. Has it done that? Initially, for maybe the first half or the first half decade or the full decade after this 96 Act, etc. came in, mostly everybody was deliberating the enforceability issue. How enforceable is the award? How enforceable is foreign arbitration? Can you have a foreign venue but still be implementing Indian law, or vice versa? To get from the initial ideation, as I said, of the law and formalization to implementation has taken us more than a decade. Now things are better clear, right? More or less. Now we know foreign arbitration awards can be implemented, etc. But what benefit has it generated to us is, as I said, a scar on the corporate that is arbitration good in India. Is it worthwhile? That's maybe the timeline. You can get over that and argue today that it was a teething issue, took us time, which is fine. Now we are ahead of it. Now the next question is the expertise of arbitrators. Take an example of a shipping dispute. I am not a shipping lawyer. Okay, I've done a bit of it in vague corners. Okay, can I be an arbitrator in a shipping matter if I retire after 20, 30 years? My answer is no. But you would see people arbitrating who have never done shipping, right? That's also a challenge. Arbitration was supposed to be an expert arbitrator, and arbitration was supposed to be done by experts. But way down the line, we lost track there where to have more stamping of correctness, we went with a certain panelization, right, of retired honorable judges, which was very good, which was, I think, the right approach, because if you have that kind of mindset, your decision-making process is better and the challenges become minimal. But that did not happen because the expertise sort of lacked, because corporates were looking for expertise. Now that is coming back into the picture where you have a list with the high courts, they know who are experts, they are appointed. But how many of those do you have? Because the timeline again is the question back again, that how long does it take for you to decide the arbitration? Ideally, in my view, it should be done within 1 year. What's so great, rocket science? The idea was to get away from the CPC conceptualization of everything going by the book as in the litigation happens, right, in the court, and make it more swift and simple. Did that happen? My view is questionable. And therefore I say that is it been an exercise to reduce the burden, or it's just lengthen the process, because at some point in time you will do the arbitration and then you will be back in the court challenging it on some ground or the other, or let's say the mediation. So would you want, as me, let's say if you and I, God forbid we ever have a dispute, but you and I have a dispute, okay, would you want to go to mediation where you and I both know it's optional, I can back out or you can back out, or you would want to go to the court? You would say, at least I have some certainty. Maybe it will take 3 years, but I'll save 2 months or 3 months or 6 months. That's the issue. So somewhere, some of these sets have to be done. And I understand this issue, that it is also the issue of appointments and manpower restraint that we have today, right? So it is difficult, and that's where I said some of us, and you should take this as an apology from my side, I should have covered in the first slide the judicial services as well. It's a very big mistake on my part, and I'm sorry to all of you. That's, I think, also the key, and probably the biggest key in this whole legal fraternity, is that some of us have to aim for that always, because that's where the change will happen and is actually happening. I've seen that happen. Young people going for judicial services for the right, with the right mindset, and doing it and putting forward the right foot and making things change.
Thanks, Prantap. I think we have really taken much more of your time than originally planned, and I'm sure. I mean, I can see a lot more comments and questions and so on the chat window. But we hope to bring you back, while the program is on. And of course, the great thing, which I realized only like last week, is that you stay not very far from the temporary campus, and we are hoping to have our fellows in residence by January. So we hope to also have you interact in person, very soon. Thank you very much, and thanks, students. So we have a next class coming up at 11:30.
Okay. All the best. I hope all of you stay safe. I'm sorry we could not have more time. Sharad, I hope I answered your question, but I am happy to follow up with Anant on that. But my last comment very quickly, Anant, thank you so much for the opportunity, and God bless all of you. Please take care. Stay safe.
Thank you.